Awesome. Now we're recording. But some of the things that are coming up, and I'm really excited for Francisco to share it, particularly when we talk about just ways for asset protection, stuff like that, because, in times of a lot of appreciation, in times of a lot of things that are changing really quickly within the industry, within, housing in general, people are making some interesting choices with what they do with their properties. And I know Francisco and I have been like, can we look at some of these deeds? Can we look at some of these? People do weird stuff. So it is very important that you guys get this information about, kind of what's going on, how you can protect yourselves, how you can protect your clients, and have these conversations early on in the process when you're talking to your clients about, who's entitled, how it's laid out, who has to sign what, because like I said, these times, we're just seeing some weird stuff on deeds, and we want it to be as clear as possible because, after the fact is a lot more complicated. With that said, Francisco, I know I set you up with co-sponsors, so you can definitely share things. If that's an issue, let me know. And with that said, I just want to hand over the floor to Francisco, and I know he'll tell about himself as well, but also want to say, I appreciate his enthusiasm for education throughout. I met him, we met a few years ago and even did like in-person classes, go figure. And even with all the education that he's been offering, and particularly when COVID hit, all this different, he's got a lot of information that he provides both, with his services, and even a lot of free advice that is really, it's really generous that you offer so much. So we really appreciate you, Francisco, and with the floor is yours.
Well, good morning. Thank you, Sarah. So I am an estate planning and probate and asset protection attorney here in Chandler, and Sarah is one of those energy bubbles that you just can't help but being drawn to. So you guys know Sarah, you've had the pleasure of working with her and seeing how well things work when you do get the chance to work with her. So I appreciate her giving me the opportunity to share this. What I'm going to do today is just kind of shoot from the hip a little bit because things are changing. I have a presentation I did about a year ago on asset protection. So I'm going to kind of work through some of those slides. I'm not going to be too formal about it. Really what I wanted to do is give you guys kind of that big picture. There it is. It's up there, right? That big picture on asset protection, because none of us want to lose our money. None of us want to lose our property. And it just all feels a little more scary right now, I think, with some of the things that are happening. You can't control whether Bitcoin is going up or down. But when you go to liquidate your holdings, you want them to be as profitable as possible and as secure as possible. So, this presentation I did last year was really all about asset protection and focused in on what are those strategies that the uber wealthy families use, and what parts of those can us normal people use to really protect what we've built. When you're protecting a fortune that's, hundreds of millions or even billions of dollars, you kind of just like the rest of us just kind of, it's a throwaway concept. We're like, well, yeah, I mean, sure, if they lost all that, they'd still have hundreds of millions left. Like for us normal people, like if we lose, like this is our life savings, like it has to be there to provide the life that we want for ourselves, our family, our loved ones. And if you ever thought that the government and the attorneys were out there to get you, I'm here to tell you they probably are. And it's really been my life's work to figure out how to keep them out of our pocket, how to keep them out of my life and your life, honestly. And so that's really what our firm does. And so I'm the founder of Keystone Law Firm. And like I said, we're in Chandler and we do estate and asset protection and probate work all over the state of Arizona. And as many opportunities as I can to share what I know and my experience and the experience of my clients, I'm going to. So I appreciate the opportunity for you guys today. But this is how bad it gets when, especially as we as we age and enter that stage of life where we can't be sort of like finding new jobs and amassing new properties, this is how bad it gets. We had a guy who, when did he call us? It was like a Monday. This is a few years ago. It's like a Monday, like late in the day, it's when all the emergencies happen at the end of the day. And it gets transferred back to me because it's like, Francisco, this is an emergency. Like, you need to talk to this guy. Okay, I put him through. So I talked to this guy, and come to find out, he's kind of an elderly guy, lives in Mesa. And he lives in just a small, simple mobile home on a golf course. And he's like, I don't know what's going on. I just found out that I got some court papers here. I don't know what they mean. Apparently, like, there's a court hearing tomorrow at 11:30, and I'm supposed to go there. Somebody's trying to freeze all my assets. And I'm like, holy crap, dude. So I send a paralegal out to get all the paperwork and meet him and bring it back. And we review all this. And I end up finding out that we've got to go to court with this guy at 11:30 the next day. Okay, so we walk into court. He's like, 75, 76, like he's in pretty decent shape, but he's slow moving and whatever. We walk in, we sit down. There's a couple attorneys in the courtroom. There's a licensed fiduciary company. There's someone from Adult Protective Services and an APS agent. There's a couple people like in the galley in the gallery. There's the judge, the court reporter, etc. Walk in, the judge calls the case and lets the other side talk first. And the attorney gets up. I've never met this attorney, never seen him in probate, never seen him in court before. I'm like, who is this guy? He gets up and he says, Your Honor, somebody's trying to take advantage of him, and we need to freeze all of his assets so that doesn't happen. I kind of whisper, I talk to him like, what's going on? He was like, I don't know. And so then they get up and proceed to present a whole case, what they call a case, about how he was trying to give somebody a few $1,000s. And so his bank sort of ran the red flag up the pole, called APS without him knowing. APS was called. APS referred this case to a private fiduciary and a private attorney who has no prior relationship with this guy. And they all prepared this whole lawsuit against him to freeze all of his assets without him even knowing. This is called an ex parte proceeding. So he didn't even know this was all being filed or happening. And somehow he got wind of this court hearing. I don't even really remember how he got wind of it. And so they present this whole case about how he's being exploited, and they need to freeze his assets. The court needs to freeze his assets so he doesn't get taken advantage of. It's 11:55, and the judge turns to me and says, well, Mr. Servette, would your client like to present his side of the case? And I'm going, obviously, yeah, we just found out about this yesterday. We need to, he's got to go get records. I can have him testify. Obviously, this is ridiculous. And the judge says, well, actually, you know what? We're about to go to lunch, and I've got a whole afternoon of other court hearings. So unless you have some evidence to present, I think I'm just going to rule right now. And Your Honor, I object for the record. You cannot rule. My client has a right to present his case. You can't rule in their favor. And the judge says, well, if you don't have any evidence, I really have to be concerned about this. So I'm going to grant their order. And he ordered that day, froze all of his assets, restricted his real estate, froze his kind of modest but important to him IRA account and his bank accounts that day, right there on the spot. And what ended up happening over the next about a year, maybe it was about 14 months, was we battled like hell to get him out of that process. And in the end of it, the court granted those lawyers and licensed fiduciaries all of their attorneys, all their fees out of his estate, out of his money, because the law allowed for it. And it ended up costing him close to $120,000 in fees. And that's
horrifying. That's absolutely horrifying.
This This was a nightmare. This was an absolute nightmare. And if I was allowed to cuss, I'd be cussing right now my head off. It was a bank that called APS in the first place because they thought maybe he was being taken advantage of. And this is just one example of what I truly believe we need to protect ourselves against and protect our assets against. This guy, he passed away 2 months later after this whole thing was done. And at the end of it, his IRA was almost gone. It was about $200,000. It was almost gone to all those fees and costs. A little bit left went to a beneficiary. And then the only thing left after all those fees and costs was his house, his mobile home. And his beneficiary was able to sell that. There were some liens against it from that whole court case that they had to pay out of that. And none of it was protected. None of it was. And it was all subject to this nightmare process. This whole thing is happening. It's still happening every day, especially to our elderly population, because that's where this reporting procedure to APS happens. That's one specific area of risk that I know deep down in my heart we need to protect ourselves from. That's one of the areas we're in the most. And so that's why it's so just like near and dear to my heart. The Rockefellers, I mean, they had all kinds of protections in place. Even now, like the family office that manages all the aspects of that business, it is a business now. I'm going to share with you guys what I think are the 4 different aspects, the 4 different areas that I know they focus on. Yeah, just like the movie I Care a Lot. Oh, you got to watch that movie. It was exactly like that movie. I think there are 4 areas that all of us need to consider part of our asset protection plan. And I'm going to go over what those 4 are. Essentially, it's trusts and all different. I'm going to go over the different kinds. It's business entities and all the different kinds. Insurance and all the different kinds, and then a very intentional process that you have with your family or your loved ones. So I'm going to go over those 4 things with you. The dreaded slide. Yeah, I always have to have this one in here. So the state bar makes me say this one. This is not legal advice for your specific situation. This is general information of an educational nature. So I hope you learned something. I hope you take away a couple big nuggets and you can go like, yeah, I can do better with that piece and awesome. That's great. But don't just dive in and say, Francisco told me. Well, Francisco is trying to educate. And if you want specific advice, seek the advice of an attorney. Now, before we get started, I just have to tell you guys a little bit about my background because any chance I can to brag about my family, I'm going to. It was my wife, my 4 kids. And I will always brag about them because I think they're awesome. My firm, our goal is to just protect people's assets and protect their families at the same time. I know this slide says $750 million, but we're at over $1 billion now protected. And that's just really cool. Like this is $1 billion of families' net worth that is protected. And that's pretty exciting for me. I kind of fell into estate planning on accident because I really enjoyed the strategy of it. But I looked back at my family and realized how important it was it's specifically my mom's dad and my dad's mom in their lives and how it really affected them. My dad's mom was actually a widow, really, really, really young. She inherited a decent amount of money from my grandpa, who I never met. He died when my dad was only like 6 years old, but she inherited a good bit of money from him. He was a pretty savvy business guy. I don't know exactly what he did, but the story goes that he left her a pretty decent amount of money, but without any real structure, strategy, long-term thinking in place. It was more just a bunch of money. And she was the traditional wife at the time. No exposure to financial training, no understanding of how business works. And she sought the advice of the people in her life. And one of them was somebody who we all still are told, and we all have no reason to dispute this, was a well-meaning family member that had a good investment for her, but ended up losing all of it. And so she ended up having to raise her 6 kids herself, basically working, 2 or 3 jobs at a time. And so I just look back at that example and think, how much better of a gift would it have been to leave her, the assets with a strategy, with a plan, with some protection in place. And so those are some of the things we're going to talk about. And then my grandpa on my mom's side, he kind of approached things a little bit differently. He actually did a really good job passing on his stories. He actually wrote out stories from his life and passed those out in a book. And so anyway, that's a different piece of what I'll talk about someday, I guess, in the future. But what I think where I start, whenever we are talking about asset protection, I always start with, what are we protecting from? What's the risk? Because the risk is going to tell us what strategy we use to protect it, okay? Not all risks have the same strategy, so they have different mixtures, okay? We're trying to protect from taxes, it's this thing. If we're trying to protect from lawsuits, it's this thing. So it's different. So we'll talk about what are the top risks. We'll talk about the asset protection strategies, and then just where do you even start? Like, what's the starting point with this? There's kind of too much to even learn, right? Realistically, right? Nice grim picture for effect. This is our biggest risk, I think, right now, and has been for a long time. Arizona, we have terrible drivers. Oh my gosh, if you guys haven't noticed, we have terrible drivers in Arizona. The last time I looked up the statistics from the Department of Transportation in Arizona, 3 people every day in Arizona die in a car accident. 3 people every day, just like cruising down the 60, headed home, and bam, they never get there. Or out on a date night, my wife and I, we got 4 kids, out on a date night, bam, hit by an 18-wheeler, never make it home. 3 people every day. Like, where are you headed next in your day today? Like, I've got to drive to the office in a little bit. I'm working from home right now. And, it's like, yeah, I'm headed out on the roads. Am I really that worried? Well, it's our biggest risk, honestly. The same road that I take every day between here and my office, somebody was killed in a car accident. It's like a very untraveled road, and someone was killed in a left turn accident just this last year. This stuff happens, right? So just these kind of massive, devastating life events. Divorce, like, it's a real thing. How do we protect ourselves in case of a divorce? There are ways to protect your assets from being torn apart, and then worse, from being depleted just by the lawyers fighting over it. But then the other side of divorce too, I think, is important, is what we're leaving as an inheritance. You don't want to leave it to your kids and then watch them get divorced and then it end up in the hands of the in-laws, right? Like, I'm naming my daughter, not my soon-to-be ex-son-in-law kind of a thing. So, divorce is a big deal that can really devastate and destroy your assets. Last year's statistics are available. 51,000 lawsuits filed in Arizona. There you go. 51,000 lawsuits filed against someone or against multiple people. That's in 1 year. These things go on for years. So just lawsuits in general, huge. Like, none of us want to be dragged into a lawsuit. Medical events are scary. We deal with, we help with a lot of families who are in that stage of life where medical issues are a big concern. And it's hard enough to navigate the medical system. Blech, none of us enjoy that these days. But the cost of medical care, that gets really scary as we age. I know average medical costs for somebody over 65 can get to the last few years of life out of pocket can be $250,000 in cash out of pocket. So you don't want to have to deal with that. We deal with a lot of probate issues. Probate is ridiculously expensive in Arizona. There are two types of probate. There's one during life, and that's the one I described about that guy when the first story I shared with you, where they dragged him into probate during life and got his assets frozen. That happens in probate court. Lots of things happen in probate court. And then what happens after death, the typical probate, I mean, these fees can eat. This was a guy who wasn't wealthy. He owned a mobile home worth maybe $70,000, $80,000, and he had maybe $200,000 in an IRA and a little bit in his bank account. Literally had a 6-figure fee because he got dragged into probate. Over 6 figures. This is a huge, ridiculous expense that's completely avoidable. So those are the risks that we run into, right? And that we're trying to protect against. The strategies. Here's where I kind of want to spend my time. I want to start with this. If the only thing you walk away with from this time is a understanding that a living trust gives you no asset protection at all, none. Don't assume it does. Somebody tells you it does, they're mistaken. I'll give them the benefit of the doubt. A living trust does not give you asset protection. You put all your stuff in a living trust and you get sued, they can come after all your stuff in your living trust. Okay, a living trust is intended only to make it so that you don't get dragged into that probate case like that guy did. That's what it's intended to protect against. It's intended to keep control over your assets while you're here. You control your stuff. If something happens to you medically, you become incapacitated or whatever, you've already spelled out who can take over control on your behalf. Maybe it's your spouse, maybe it's a child, whatever. And then if you pass away, it's spelled out in there who has control after you pass away. That is what a living trust does. It does not protect your assets from your creditors. Someone sues you, you have credit card debt, whatever, that's all the same, okay? There are other kinds of trusts that can give you asset protection, okay? So that's what we want to dig in on. Here's the first of the 4 strategies. So these are all of the asset protection trusts that I could think of when we were creating this. Now, as you research things, if you Google around, you go to different workshops, you'll hear lots of different trademark names about asset protection trust. You'll hear irrevocable. You'll hear these acronyms, IDGT. You'll see ILIT. You'll just see all these weird names, and you'll be like, which one is which? And unfortunately, I will say unfortunately, my industry has not standardized that stuff. And so every office basically gets to come up with their own naming convention. So when you see something in one place, it doesn't mean it's different than something somewhere else. It also doesn't mean it's the same. I mean, it's really unfortunately confusing. So here are a number of the ones that we see used, okay? Dynasty trust, spousal trust, lifetime trust, charitable trust, beneficiary trust, retirement trust, life insurance trust, grantor trust, defective trust. The last 2 I just did in acronyms because they didn't fit: domestic asset protection trust and a foreign asset protection trust. Those last 2 are probably the most fun, the most interesting. They're also the 2 that are honestly the hardest to live with because you give up quite a bit of control in order to set them up. But they do have some of the best asset protection characteristics. So I'm going to cover those real quickly. The only difference is one of them, the domestic one, is set up here in Arizona. It's an Arizona trust. A foreign asset protection trust would be set up either in another state or even offshore, Virgin Islands, Cayman Islands, whatever. The whole trick there is under neither of them are you a beneficiary right now anymore. So the strategy goes like this. I've built up my wealth. I have some real estate, I have some investments, I have some business that I operate or whatever. I can look at that when I get to that point and I can say, you know what? I've got more money than I'm ever going to spend. I've got assets that I can't really deplete over my lifetime. Like I'm just not going to, but I really enjoy building these assets and investing and maybe flipping the real estate and just growing my wealth. Cool, awesome. Keep doing that. But what we're going to do is we're going to carve off a chunk of it and place it into something into one of these, because we know you don't need that money. The rest of it is more than enough to satisfy you, plus whatever income you have for the rest of your life. Great, let's carve this off. And you can continue to manage, invest, direct, whatever, like keep flipping, keep building businesses. You can keep doing it, but we carve it off of your personal income statement. We put it into one of these asset protection trusts. Now, if it's a domestic trust, you cannot be a beneficiary. And we recommend most circumstances, you're not even a trustee. So you're going to appoint somebody else to be the trustee, and you're going to then name somebody else as beneficiary. Maybe it's your spouse, maybe it's your kids, that's fine, but it's not you. And then on the foreign asset protection trust, you have a little more flexibility to actually be participating as trustee or beneficiary, but it's foreign, right? You can't you're literally transferring assets out of the state or out of the country, depending on what level of protection you want. Both of these types of, actually I should say, all of these types of trusts are irrevocable, meaning when you set it up, you can't go in there and just change it as easily as you want to. There are tax consequences to all of these when you do that. And some of them, you're getting money out of your estate so that there's no estate tax when you die. Some of them, you're not worried about the estate tax, you're worried about the income tax. You're getting the income off of your tax return onto maybe your beneficiary's tax returns. And they're intended for different purposes. I mean, you can see dynasty trusts are intended to go forever. Arizona allows you to do it for 500 years. So essentially forever. A spousal trust is me saying, I want to put this into a trust for my wife. And you can set that up so that it's got some asset protection around it. A lifetime trust would be, maybe you want to support an adult child, or maybe we have one client that they've got 2 kids, they love them to death, they're adults, but oh my gosh, they're just not financially responsible, and they're still supporting them into their 40s. And so what they decided to do was just carve off a chunk of their portfolio, put it in a lifetime trust for their kids, and say, you know what, kids, you're not asking us for money anymore. You're going to the trust. And this trust is here to give you this and this and this and this. And so, okay, you can do that. And that's asset protected now. A charitable trust, some really cool varieties in there because you can get some extra tax leverage on it. But probably the easiest one to understand is a charitable remainder trust, where, how do I explain this one? So in this one, what you do is you take something that if you were to sell it, you would pay lots of taxes on it. And so this is one of the tax law changes that's potentially pending, is the capital gains tax rate. So this may become a strategy that a lot of people need. But say I bought a house for 100,000 and it's now worth 400,000. If I sell it, I've got 300,000 of gain. So I pay capital gains tax rate on that. Well, let's say I've got a whole lot of those and I'm just like, crap, I don't really want to be selling. I'm done investing. I want to sort of liquidate and get out of real estate. Am I just stuck cashing in and paying all this capital gains tax? No, what you can actually do is take all of those and bundle them and put them into a charitable remainder trust. You get a tax deduction for that. And the charitable trust now, because it's a charity, it can sell off everything and it pays 0 capital gains tax. Woohoo. So then it gets that full sales price in there. And then it can reinvest and redeploy and do whatever you want because you're the trustee on that. So then there's strategies on how that comes out and gets paid back to you, what happens for your beneficiaries. But essentially there's this small remainder you got to leave for charity. So there's a lot of details in the charitable trust there. And that's one of the other trusts. Okay, so let me keep going here. So the first thing is asset protection trust. The second thing we see a lot of use, and we use a lot for our clients, are businesses and different types of entities. There's only really 3 types of entities. There's LLCs, there's partnerships, and there's corporations, C Corps, but there's of course varieties of each of those. And the ones that we see used a lot for an asset protection standpoint are LLCs and corporations and limited partnerships with What I would say is a good baseline understanding of how asset protection works when it comes to the business entities is if you are a sole member, there's no partners, there's no other joint owners, it's just me and I own my LLC or my PLLC because I'm a real estate agent or other licensed professional. If you're a sole owner, there's no partners, that entity, I would say, don't count on that entity for giving you asset protection, okay? Don't count on it. Don't rely on it. Don't like hang your entire financial future on that. Here's what I would say. There's two different types of asset protection, or there's two different directions, okay? You've got your LLC over here, and you've got your personal life and your house and your personal stuff over here. If inside the LLC, there's some liability created, you own an apartment building and God forbid, but somebody drowned in the pool. Guess what? They're going to sue you. I don't care if you did everything reasonable. They're going to sue you. Let's say you lose and you get a $10 million judgment against you. Inside of this LLC, let's say it's inside of this LLC, they're suing the LLC and the LLC ends up with a judgment. Well, they're going to come after and take all the assets. And if it's not enough to satisfy that liability, can they get out of the LLC and then come after your personal assets? Okay, that's one direction things can go. The other direction is you're just out driving around having a good day. Personally, you get into a car accident, you kill someone, they sue you personally. Can they then come after your LLC assets? Okay, so that's called inside out and outside in asset protection. If it's a single member entity, don't hang your entire financial future on that. Keep those entities owning very, very little. Like, that's not where you want to own your portfolio, where you want to own your assets. You want something different. And so what I recommend with business entities is that you add a partner. Yes, I know that's tough sometimes. It doesn't have to be 50-50. Generally speaking, you can add someone and generally, say 10% owner. And that's enough to create that multi-owner reality around that entity. And that's where asset protection can start, okay? At least that's what we talk to our clients about. Now, what do you do for that 10%? I don't just want to bring in a random person. Can I just add my wife? Man, that's not really the way to seal it. What we recommend is find someone or something that maybe something, but find someone or something that you are kind of still in control of. And for me, it's my kids. And so what I can do is I can create an irrevocable trust for my kids that my kids are the only beneficiaries of. Just my kids. I'm not 100% them, but I'm the trustee of this trust. So that trust can be my 10% owner. So that's one of the ways to work around that multi-owner strategy. And then, of course, the more you segregate your assets into different buckets, different LLCs, different partnerships, et cetera, the better. Because if something happens in one of them, again, you have that whole, can it get out to your other assets? Or if something happens in another one, can it get out back to that one? So consider having different entities for your different assets. That's at least a pretty standard thing. Now we have some clients that they have a very heavy operational business, like a plumber, like a plumbing business, where they've got 15 trucks, they got plumbers driving all over town and going into people's homes. It's kind of scary when you think about it as a business owner. So you can segregate aspects of the business, right? So you might have all the vehicles owned over here, and you might have the plumbing operation over here, and this plumbing operation just leases its vehicles from some other entity, happens to be that one. Or another example is property investors, right? You're gonna own, you own 5, 10, 15, 20 houses, and you rent those out, well, you can have each one of those owned by an LLC, but you have this central LLC that acts as the manager that receives all the rent, and does all the finds tenants and repairs and is the manager. Well, that entity doesn't own any assets, but they might be taking on all the liability of the management of all the assets. So you segregate different aspects of the business and keep the asset itself as far away from operations as possible. Okay, insurance is not fun at all, but it is here. I always say insurance is your first line of protection. It is, and I recommend it, even though I don't sell insurance, right? The first line of defense is insurance. When I was in law school, I clerked for a lawyer. All he did was he got hired by insurance companies when businesses got sued for something that was covered. So somebody would slip and fall at Walmart. Walmart's insurance would hire this guy to defend Walmart from the slip and fall deal. We had one where we actually had an apartment drowning where the apartment insurance hired them. We had one, just all kinds of things, right? Your insurance is that first line of defense. Malpractice insurance for us attorneys, E&O insurance for real estate agents, whatever, right? And then personally, you're going to have your car insurance, your homeowner's insurance, and add that umbrella insurance. It's super cheap. It's the cheapest form of protection you can get. And here's why it's great. When something happens, you turn it over to them and you say, defend me. Defend me. Go hire a lawyer. Go spend all the money. You defend me. And guess what? Settle it too, out of your pocket, not my pocket. That's the beauty of insurance, because if they can settle it within policy limits, you're good. You don't have to worry about all your other assets. That's the first line of defense. If it's going to end up being a liability beyond your insurance coverage, that's when the asset protection plan kicks in and gives you the negotiating power to negotiate something that you can live with. I didn't say this up front, I'll say it now. An asset protection plan is any good lawyer who knows this area should tell you, an asset protection plan is not a reason to fight something tooth and nail to the bitter end because you feel like you've got this fortress around you. No. Your asset protection plan is here to help you negotiate a settlement that you can live with. That's what it's there for. It's there to show the other attorney, yeah, if you ever even do get a judgment, you're going to have to break through all these walls of protection before you ever get to an asset. And they're all doing it on contingency anyway. They don't want that much work. They just don't. And trust me, they don't. They want a quick settlement. They want to be able to give a check to their client and keep part of it for themselves. That's what an asset protection plan is for. So anyway, insurance is always first. And then the last thing, this is a critical strategy nobody ever wants to admit it. Nobody wants to talk about, nobody wants to implement, nobody wants to do, because, it's just communication is the hardest thing to do. And if we don't do this, then all the rest of the things it's going to be really hard for them to be successful. The best asset protection plan, it'll fall right apart as soon as somebody in the family does the wrong thing and uses the money a little bit the wrong way. And then now there's a whole allegation of piercing the corporate veil. So when you set up an asset protection plan, one of the things that we see works really well, depending on what level of wealth you're at, is to bring in your adult children or your adult family members who are going to inherit anyway, and start to include them in the conversation, to treat that asset protection plan as if it's your own little separate business, even if it's just sort of, your investments. Treat it as a business and start including them in those quarterly meetings, biannual meetings, annual meetings that you're using to make decisions, about how are we going to invest, how are we going to redo things, what are the issues we need to deal with, what changes do we need to make, whatever, and start to give them that more and more and more information about what's happening and how you think, so you can brainwash them into agreeing with you a little bit. But this is just something that I've seen used only a few times. Only a few of our clients see the value here, but when they do it, this is golden. This makes a huge difference. And it actually brings everybody along in the same page. What I see happen more often than not is that the person didn't do it, then they die, and then now what does the family do? They fight about it. They fight about it because nobody's really in control, or they don't believe that the one person should be in control. They don't believe they're doing the job the right way. They're fighting. And there's enough money there for everybody to go hire lawyers and spend hundreds of thousands of dollars on legal fees. And you know what? Fine. Should I complain about that? I'm just warning you guys about it because I don't know. I think there's enough families out there that would do it the right way. There'd still be enough to keep all those terrible lawyers busy. They're not all terrible lawyers. It just happens, we get called upon in those. We're getting involved in 2 of those right now because the parent didn't put together the right kind of plan and didn't include anybody in what they were doing. And so now it's just a big mess. Nobody really knows what's happening. So the more you can look at it as a family business, I think that's a tremendous amount of value for your family. All right, where do you start, right? It's like drinking from a fire hose. And, in just one quick meeting, we can't cover everything. This is something I'm a big proponent of, is these 1-minute decisions. So in our very, very traditional, like basic, good, simple estate planning stuff, I run into a lot of people who are like, yeah, I just don't know what I would decide. Yeah, I don't know who to name. I don't know who to leave it to. And that's this sort of socially acceptable way to think about creating any kind of will or anything, right? Is we all somehow, the public, the world at large has said, if you're not quite sure, if you don't have like that epiphany from God that says this is the right decision, then it's okay to put it off. And I'm here to tell you that by putting it off, that's why we still have 14,000 probate cases filed every single year in Arizona, even though we only have 60,000 people die every year. How is it that we have 25% of the people who die in Arizona end up in probate? It just blows my mind. It's not hard to avoid. And so by accepting this concept that, well, I don't know exactly who I would name, that means it's okay for me to wait and put this off, right? I'm sure some of you are being triggered by this. I apologize. I don't mean to, but I think the better way to do it is to use these 1-minute decisions. So here it is, 1 minute, right? Imagine if I had a crystal ball and you knew without a shadow of a doubt, today was the end. Today was your last day on earth. Imagine that for just a minute. As hard as that is, right? God forbid, I pray that doesn't happen to you. But imagine for a minute that it was. Could you just please make a quick decision? Who's in charge of distributing your stuff? And where do you want them to distribute it to? There's never been a circumstance I think we're close to 3,000 or 4,000 people that we've counseled through that discussion where somebody hasn't been able to spit out an answer. Because if when you learn that if you don't spit the answer out, a judge will, who doesn't know you, doesn't know your family, doesn't know anything about you, a judge will just spit that answer out. Oh, you could probably pick something better than that. As soon as you learn that and you think, gosh, if I did drop over dead right now, at least let's have so-and-so be in charge of everything and distribute things to A, B, C, D, or whatever. Thousands of conversations. We've always had people be able to name that. In my opinion, that is good enough. That is worth putting down in legal form so that if something does happen, your family, your loved ones have that. And you know what? In all likelihood, nothing is going to happen. And you'll have time to sort of let it sit and soak. And what's been really neat is we've had the opportunity to watch clients let that stew a little bit. And more often than not, they come back and they say, yeah, actually, I feel good about that. Or if there is a change, it's a pretty minor change, because what our mind does is it like checks it off as being 90% done. And then our brain has all this space now to just really consider that 10% that really I was just really wondering about. And so then we have a lot more capacity to ruminate on the ideas that are available for that 10%. And so then we can finally come to some decision about that little thing we were still wondering. And then that's all we have to change. Really simple. So anyway, I'm a big, big fan of 1-minute decisions. And that's why we say just start small, build it over time. Start small, build it over time. Get that base thing in place. You know what? Over time, you tweak it, you change it. Guess what? Most lawyers haven't discovered that there are these things out there called computers, where we save our clients' documents and we can make edits, and it's really easy, you know? So it doesn't have to be complicated to get changes made either. So anyway, that's how I would start. Start small, and same thing with your clients. Start small, build it over time. It's not hard to make changes to these kinds of things. Okay, I'm like out of breath here. That was like all I had on my slide deck. If you want to schedule, we do a free consult. You're welcome to jump on that bit.ly Keystone appointment and schedule. There's a free option on there for you if you want, Sarah. You're welcome to
send it out, and I'll send it out so it's clickable.
Awesome, even better. And I'm happy to stick around for a few minutes and answer questions. You know, I think probably the easiest way to do it is if you guys drop it in the chat, just so it's not like a free for all. On the audio doesn't quite pick up as well on Zoom as we all would hope it does. So feel free to drop one. I've got a question here. So, okay, actually, this is a good question. How do we identify probate homes that we can get on a list from the court to help with probate real estate sales? You know, I actually don't have the referral in mind for you, but there was a list broker, and all he does is he just gathers that data up. And it probably wouldn't be too hard to find from one of your guys' brokers. I bet they have access to those marketing sources, is who are the list brokers. And it was something ridiculous cheap. It was like 25 cents per name or something like that. So you can probably get those just on a list. The court also does maintain something called a probate master, and that's a different level of specialization, where you go through some education, some training, and prove your experience, et cetera. Then the court will put you on their internal list for acting as a probate real estate master, where you can act as that neutral third party who has full power to sell real estate without the parties who are fighting, without their consent. And that's a different list. Let's see. Can your trust own your PLLC? And why would somebody want to do that? So this is unfortunately an area that's not very clear in our law in Arizona. And since it's not clear, I think the option is up to you whether you want to do that or not. What I have recommended for our clients is that you take your trust and you have an internal private document assigning the interest of your PLLC to your trust at your disability, incapacity, or death. And then, but keep that private there. But it's fully signed and executed. And then if that event ever happens, your trustee can then take that document and go to the bank and can access the bank account. That's usually what most of our PLLC clients only own in their PLLC, is a bank account. If there are other assets you own, my recommendation is to use this as the time to segregate those If it owns real estate, pull that real estate out, own it in another entity. If it owns anything else, I would recommend pulling it out and just keeping that PLLC as it only owns that business operating account that you need to own.
Okay.
So, Francisco, we've seen it come up a little bit with, with certain deeds, in that people are creating beneficiary deeds. So when they pass away, but the beneficiary deeds it into the trust. Why would somebody want to deed it into the trust? Why wouldn't they just put it in the trust to begin with? So it goes from, when the person passes away and they own it as the entity in their name.
There's a couple reasons. The first reason, while someone's alive, if they've got a mortgage on that property, it's not, there's nothing illegal about moving that mortgaged primary residence into your trust while you live there. You're protected under federal law to do that, et cetera, et cetera. The problem by doing that is when we've just seen when somebody has a mortgage, that person is very likely at some point to refinance that property. And during the refinance, they forget to put it back in the trust. And so they go around and they do life, and then they pass away, and there was a trust deed way earlier, but then it wasn't finished up that way. So that's one problem we see. And then the second problem we see, or the second reason, is because on a beneficiary deed, when you do a beneficiary deed and you have a mortgage, you do a refinance, the beneficiary deed is still hanging out there. It's still covering that piece of property. So you can refi 100 times, the beneficiary deed is still on that property because you aren't changing the title with a beneficiary deed. And so that's why we see a lot of clients choose the beneficiary deed option. And then the other reason why you might do a beneficiary deed to your trust instead of just to the beneficiaries is because your trust can have extra advantages of receiving an inheritance. One of them being that your trust can give it to your beneficiaries with asset protection. So I can leave it to my kids in a way that they can't sell it till they're 25. Someone can leave it to their adult kids with asset protection around it, where they can't lose it to creditors or divorce, et cetera. And then the third advantage is there are backup and contingency plans in a trust, whereas there are not on a beneficiary deed. So if you say, give it to my 3 kids on my beneficiary deed, one of them happens to be deceased or incapacitated, then that's going to end up screwing up inheriting and being able to sell that property after they pass away. So that's a couple other reasons.
Thank you.
Yeah, you bet. Any other questions? Happy to answer any at all. You guys are too easy on me.
Yeah, you covered a lot.
You guys are way too easy. Well, I'm happy to follow up. You guys, I'll just put it in the chat. My email is my first name at keystonelawfirm.com. And anytime any real estate agent wants to ask questions, brainstorm stuff, discuss whatever's happening, for a client or issue, I'm just a phone call and email away. Sarah does it. Lots of agents do it. No big deal. I'm always happy to be a resource for other professionals, and you don't have to go through the front office. You'll never get to me. So use that access however you want, and I'm happy to point you in a direction.
Fantastic. Well, I appreciate you, and I know we've had sometimes questions come in after the fact, so I'll be sure to share all this information. And then any of the information, thank you for putting in the bit.ly link. So we'll make sure that we share it. I know that you've got, like you said, the consultations. We'll have that information out to you. Francisco and I do talk about, just because deeds and how it falls and, how it's all like set up. We do a lot of research. So, definitely let us know if you need us to do some homework ahead of ahead of things and then see what we can do. If, Francisco is asked, answer a lot of questions. Like you said, I've reached out and, unfortunately we had a case where one of my colleagues' mothers passed away and she was on life support and they had to make some decisions and there was nothing. And so there was all the guilt and all the challenges of what are we going to do now during this crazy emotional time. And so there's a lot to be said for having this set up ahead of time in those 1-minute decisions, because she did not want to have to make that decision, which, did fall on her shoulders.
On kind of related to one of the first things you just said, I'll just point out, since I know we have a lot of real estate agents on this call, is that something that came up recently was the authority to enter into a listing agreement. And that is something that can be challenged when it comes to any issues, is whether or not you have the right person sign your listing agreement, right? Or even you're acting as a buyer. You want to make sure you're getting the right person signing that, right? And so if you're on the selling side, I don't know if I'm totally asking something more of you than you're willing to give, Sarah, but I would recommend asking Sarah, hey, am I getting the right person? Am I getting the owner of the property here? Because if you don't get the correct owner of the property, then you don't have a valid listing contract. And I know we've been able to have Sarah do that, and she's like super fast getting stuff back to us, which is great.
Yes.
But what happens is you get it going, you get a buyer, and then you get an escrow, and and title says, hey, who's this you're working for? They're dead. You got the son to sign, good for you. Or you got mom to sign, but dad, where's dad's signature? Oh, he's incapacitated. Well, he's on the deed. That just has to be, you have to get both of them. So I definitely recommend using that
yes.
as a moment to just say, who's the owner?
I pull it all the time, and I'm happy to. I absolutely recommend doing that, because you're absolutely right. We got a contract once, and it was the niece who had signed it, and the people in title, there were 4 siblings in title from a quitclaim deed from 1978.
Ew.
Yeah, exactly. Needless to say, the house didn't sell, and it may, here we are 5 years later, it's probably still in probate. I mean, it was a mess, but you want to avoid all of that, especially now to get a listing. You want to be able to sell it, because there aren't that many of them out there.
Yep, for sure. Well, thank you for the opportunity, Sarah. Nice to meet everybody. Happy to answer any questions y'all have. Just reach out to me directly.
Awesome. Thank you for your time. Thank you for everybody who joined us. Any questions that come in, let us know. And we look forward to doing this again with all of you. So thanks again, Francisco. We really appreciate your time.
You bet. Bye.